Welcome to the Owen Frobel All Things Legal webinar. Now, we're having to pre-record this because I have on screen with me here three of some of the busiest people I've ever met. So trying to get them all in one place is always a bit of a nightmare. So actually what we're doing is we're pre-recording this, and thank you to those who have registered and uploaded questions. We're going to cover those for you today. If, however, because it's pre-recorded, when you catch it further down the line, if you see it kind of further down the line and you have some questions that haven't been answered, please put them in the comments below, be that on the night it's live or further on social media, and we will make sure that whichever one of us needs to come back to you does come back to you with an answer. So anything we don't cover, let us know, and we're more than happy to come back to you for it. So to introduce the three of them here, so with me today, I've got Sarah Buxton from Buxton Solicitors. She's going to be doing a little bit talking to us about HR headaches. And I've got Katie Taken from Shakespeare Martineau Solicitors. She's going to be talking about essentially the process of sale, all the individual factors of it. And I've got David Nezri from Abraham's Dresden Solicitors, who's going to be talking to us about main delay factors, of which, to be honest, there are many. So, we may need to make sure there's a big chunk for him. So let's start with you, Sarah, because obviously I think, Katie and David are more focused on the once a sale's agreed. For you, you specialise in HR, so you are always on call. And tell me about HR factors, HR headaches in nurseries at the moment. What's going on?
Well, what isn't going on when it comes to HR and employment law at the moment? At the moment, we've got lots of legislation that's just come in this April. And therefore, lots of nurseries are having to update their employment contracts and their policies and procedures. Because if you haven't done so, and you haven't looked at them, they will be currently out of date and not in line with the current legislation. So it's a really busy period for owners and managers of nurseries because there's a lot of paperwork involved at the moment. And of course, when you are changing or updating terms and conditions, usually the staff can be a little bit suspicious. Why are you updating my contract?
Yes.
You trying to sneak in. So it can be a managerial headache, having to give out new contracts and explain why you're updating them.
Yeah.
But it's important that we do keep up to date with the contracts. And if you haven't looked at the contracts and policies and procedures, they will need updating in accordance with the current legislation.
Yeah. Okay. And also, I mean, with my sales hat on, the contracts, it's actually almost a good way to get those updates and get all your contracts in line if you are thinking of selling in the next few years, and make sure they're all in place and in one place as well. Because often you lose bits, or they get scattered, or you realise that people's contracts are very old and have never been updated.
Oh, absolutely. When we're doing the due diligence on a purchase or sale, there are lots of employment questions that are asked. Actually, for a buyer, it's one of the most important elements. Because they're going to take on these people, and they need to know, for example, what benefits they're being provided with, how many days holiday that's in play. What's the statutory sick or contractual sick and sick pay is one of the updates that has come in this month, for example.
Okay. So what's the update there?
So what has happened is that previously you used to be able to have 3 waiting days when somebody went on sick. So you didn't have to pay them for the first 3 days of sickness. What would happen is that after, on the 4th day, if they carried on being sick and they were off for a week, they would then be able to go and get a sick note, and they would be paid statutory sick. There was also a lower earning limit. So if you had somebody that earned under a certain amount, they may not make enough contributions to receive statutory sick pay. Both the waiting days and the lower earning limit have been removed. What that means in practice is that majority of the team will receive statutory sick pay now from day one of being out. And it's a financial headache for nurseries and businesses. We're going to have to build that into our businesses, that we're going to have to pay for sick. And also what that does mean is that we're going to have to really look at the sickness procedure. because we really need to be on top of managing sickness now, because we can't rely on the fact that somebody will be unpaid on that day off
Yeah.
as a deterrent.
Yeah.
So the contracts will need updating in relation to sick. And what's nice on a sale is that if you've got your contracts all up to date and all in line with current legislation, for a buyer, when you look at it and you know, oh, those are all relevant to the team,
Hmm.
really good written contract. I'm not having to ask copious amounts of questions
Yeah.
about sickness. Then that can make the process much more
Oh,
streamlined.
absolutely. And so you said there's been a lot of updates. So what else have we seen in the last month or so?
Yes, Leah. So other updates that have come in. The first is that we've got another enforcement body, which again, lots of people are not aware of, and this is called the Fair Work Agency.
Okay.
And basically, this is a body that has the power to be able to come into your business, so your nursery, and they will be able to check whether you are paying the staff correctly, whether you're giving them enough holiday, and paying them correctly, their holiday entitlement. So they actually have the power to fine you if you're not doing it properly. And the one thing that is quite shocking is that even if the employee doesn't want to make a claim in the employment tribunal, they are able to make a claim in the employment tribunal on behalf of
Really? Wow.
against you.
That's
And
amazing.
you have to pay their legal costs for doing so. So I think we really need to be aware of this
Yeah.
another body. So it's different to HMRC, it's different to the Employment Tribunal. Like I said, they have power to be able to come in and look at your documents. And it's supposed to, the idea behind it is that they want to ensure that the compliance side of having a team is being dealt with properly by an
Mm.
or a manager. I think it may have something to do with the fact that the employment tribunals are jam-packed, and if you received a claim today, you probably wouldn't be in a final hearing until 2029, given the notices of hearing that we're getting through at the moment. And I think they've created another body to maybe try and reduce the amount of claims going to the employment tribunal. But what it does mean for anybody that's running a business is that you have to make sure your HR compliance is on top form.
Yeah.
Because you've got this external body that can come in at any time. Now, that does sound, I'm a business owner, I just think, gosh, another body.
Terrifying. Yeah.
Yeah. But I think what we should look at is the positives. And when it does come to a sale, if you do have your HR compliance in good order, it will make it so much smoother in terms of a process for you. So although on the face of it, you're probably just sat there going, this is a nightmare.
Overwhelming. Yeah.
Something else for me to think
Mm.
about as a manager. But actually, I think let's look at the positives. And the positive is that if you're doing everything correctly, and you know about the different types of leave, annual leave, sick leave, parental leave, and so on, then it shouldn't be a big ask.
Mm.
And I've just been telling a lot of my clients, you will do a lot of the compliance without realizing.
Hmm.
So, for example, pay slips will show a lot of what's being paid, how much holiday they're taking, their gross amount, and so on. Usually a lot of businesses have a really good spreadsheet where they record the different types of leave that an employee is having, and that is enough. You don't have to buy any fancy app or sign up to anything that's going to cost you money to ensure compliance. But you do have to have the knowledge that you are providing the correct, for example, annual leave entitlement,
Yeah.
which is still 28 days as a minimum for an employee.
Okay. So I've got a couple of questions for you. So some people will come in with some very specific things. I say specific things. I mean, they're quite common in nursery, but let's see kind of what your thoughts are on this. So one person said, I have a member of staff who's been with me a long time. as they're getting older, they're not as mobile as they were, and they do look like they're going to need to have a knee op. How do I manage that, considering their job is on the floor with the children, up and down, running around after kids all day? What should I be doing?
Yeah. So in that situation, ultimately, the person is incapable of doing their job role.
Mm.
And when you believe that somebody's incapable of doing their job, the first thing we would advise is that you either get occupational health advice or a doctor's report, whereby we look at whether their ailment satisfies the definition of a disability. That's the first thing. And also whether there are any adjustments that you need to make. You are under a duty to make any reasonable adjustments. I say reasonable. So just because, for example, they can't get up the stairs doesn't mean you have to put a lift in. That's disproportionate. So if you can't make those adjustments, or it may be that there are no adjustments, and occupational health might say, at this time, they're incapable of doing their job, then we would go through a capability procedure to bring employment to an end. And I won't go into detail here about the procedure because it goes off at all different tangents depending on what happens.
We haven't got all night, yeah.
Yeah, we will be here on time. But what I would say is that is where most employers trip up. It's not because their aim or their reason for the dismissal is incorrect. It's because they don't go through the correct procedure which suits that particular scenario. So it may be that they will be back to work within a certain amount of time, and that suits you and your business, and it's absolutely fine. And then we can support and help them back to work. But I think it depends what your objective is, and also what the occupational health report says. That's really important. But you shouldn't think, I've got no options here.
Yeah.
I'm stuck with this employee because they've been employed for such a long period of time. That's not right.
Yeah.
You have some options. It's just making sure you go through the correct procedure.
And that's with HR, that's it, isn't it? Every time it comes back to the correct procedure, because that's often where people get tripped up, isn't it? Rather than the actual outcome, it's how they proceed it. Okay, so another question for you, and this is one where she said, I seem to be having a lot of turnover of staff in my session at the moment with people leaving. I've tried to do exit interviews and they're saying, that they're just not happy and they just feel like, it's not comfortable. I suspect it's the manager, maybe she can be quite forthright and everything like that. But how do I approach this? Because, we don't want to continue losing staff, but I don't seem to be able to find out exactly what these reasons are for people leaving.
Yeah. Okay. I think what's really important is that as a business, you look at your vision and your values. And lots of businesses still don't have these written, but they'll have a feel for what their vision and their values are. And I think it's important, if you have a high turnover of staff, to ensure that you are revisiting the values all the time, because people do deselect if they're not on board with your values. And this could include the manager in this scenario. So
maybe she's not happy there as well.
Exactly. Yeah. So it can be a case of, I would bring it back to, let's have a team meeting. Let's discuss our values, make sure we're all in the right way, like how we speak to each other, having integrity, whatever it may be that suits you and your business, making sure that everybody understands them and are on board with them. Because when you have personality issues, it's different from dealing with a skill issue. If somebody's incapable of doing their job, whether it's because they can't bend over anymore, or because they've hurt themselves, or because they just do not have the skill set, that is almost easier to deal with.
It is.
Values, because people get attacked by it. That's my personality. I
Just
can't
I am.
Yeah, I'm matter of fact. I People almost get attacked. So the easiest way to deal with it is on a team basis and revisiting the values and hoping that those people that don't have the values leave and the people that do stay with you. If that doesn't work, then you are going to have a conversation with the manager in this scenario. And don't get me wrong, it will be a difficult conversation to have. But I think it starts with having it in an environment that both people feel happy with. So people get it wrong because it could be at the end of the day when people are tired. It might be in a place where it's busy and there's people passing by and so on. So you might need to, for example, take them out of the nursery environment, just get in a place which is right for both of you. And it starts with, can I have a difficult conversation with you? And they say yes. And then you say, it is my perception. So when I've been doing exit interviews, or some people said that sometimes this is how you come across. Do you, what's your version? Like, how do you feel about that? And see what they say. And it may be that they turn around and they say, I had no idea. No idea.
I didn't realise I was doing it. Yeah.
But now that you brought it to my attention, I will try and change. And I'm sorry if I spoke to somebody in that way. Or they may be completely hostile, not take on board any feedback. And then you've got a decision to make.
You need to go the other way. Yeah.
Exactly. Okay. Yeah.
Brilliant. Thank you. I think, HR is a topic we can probably talk about for hours and hours and hours. And I imagine there are lots of questions. So if you have any extra questions for Sarah, if you could just pop them in the comments, that'd be amazing. And we'll make sure they get to Sarah and we make sure she comes back to you and hopefully, answer all your questions for you. Okay, so now, I'd like to speak to you, Katie, about the actual sale and purchase process, because I think, Sarah's talking about the HR and stuff you could do before, and obviously there's always lots of headaches, but I think a lot of people don't understand the process itself. So, can you kind of take us through that? What are your thoughts about that?
Yeah, of course. So as you rightly state, Leah, there's lots more involved than perhaps people are aware. And I've kind of split it into 5 basic stages. So the first stage, kind of preparing for sale. Obviously, when you're looking to sell, depending on the structure of your nursery business, whether you operate as a sole trader, partnership, limited liability, or a limited company, you need to consider what's the best structure for you in order to sell. And we tend to find that if sellers are a limited company, there are usually a lot of reasons why the decision to either sell the assets or the shares is important, and the main drive is usually tax. So we always advise that people should seek advice from their tax advisor or accountant on that. But from a legal kind of standpoint, it can be boiled down essentially to 2 key concepts. It's whether you want to sell the assets, in which case the buyer will only be acquiring the cherry-picked assets that they want, and the liabilities will remain with you, or if you want to sell the entirety of the shares in your limited company, in which case the buyer takes over the company, warts and all. And as I say, we find some people don't really understand the distinction, and they haven't perhaps had the advice from the accountants to work out what works for them in their personal tax circumstances. So that's one of the first things to prepare. And then one of the other things that we usually suggest as well is to undertake a form of kind of health check on your business, whether it's either, sole trader, partnership or company. So such as check through your employment contracts, check you've got your DBS checks, check your property documents are in order. If you're a company, check your company's house records and statutory registers are all up to date, any internal policies that you've got, because that can save a lot of time when you get to market and you get a buyer installed. And that's something that a lot of people don't tend to do, but it's always something that we advise.
It has to be done eventually. It has to be done eventually. You might as well get it out of the way.
Exactly. And usually before you've kind of got your buyer and you're on the kind of sales train, you have a bit more time, because as soon as the process starts, you are going to have quite a lot to deal with.
Yes,
So
absolutely.
obviously that covers off kind of the deal structure. And then once you've agreed kind of what way you want to go, where you're selling, usually advise that heads of terms are entered into between the parties. Mainly they're not legally binding, but one of the main terms is around exclusivity. And we always say that it's imperative that you get your solicitors or your advisors to review those heads of terms,
Absolutely.
because it can weaken your negotiation position later down the line. If you've agreed to something in the heads of terms, even if it isn't legally binding, it serves as a kind of good faith and a roadmap for the transaction, and it can cause
like an agreement to proceed, isn't it? And how it's
exactly,
really laid out.
and it ensures that everybody is on the same page. As you know, sometimes you don't have heads of terms, and that's fine as well, but our advice would always be that it's generally easier to have them in place, just so that everyone's on the same page, at least at the start of the transaction.
Absolutely.
And similarly, following on from that as well, NDA. Obviously, you're going to be disclosing information about your business, about your company, about your property, about your, all of the operational financial side. We always advise that you get an NDA put in place to protect not only your information that you're providing to the seller, but also anything that you're requesting from the buyer as well. So it should be a mutual kind of NDA. And then once those are all kind of in play, stage 2 is what we call due diligence. Which for those that aren't aware, it's the term that is used to refer to kind of the buyer's investigation of the business and the nursery and the company. So the buyer's going to ask lots of questions via their numerous advisors and also undertake various searches on the properties. The questions, unfortunately, are usually quite extensive, and as I touched upon there, they will deal with everything from business structure, litigation, employees, Ofsted, parent complaints, and also the financial and tax elements as well. We always advise sellers that due diligence can be a very long process, but it is imperative that the buyer understands obviously what they're purchasing, and in order to put a kind of positive spin on the due diligence process for the sellers, obviously there are benefits. Any problems are identified at an early stage, so hopefully can be ironed out and stop the deal falling over completely. And also it does assist with the production of the disclosure letter, which is a little bit later on down the line, but it kind of serves as a preamble to that element, so it saves time in the long run.
Essentially, you know what may be a problem, so you can deal with it sooner rather than having to deal with it later.
Exactly. And let's be honest, there's always a commercial solution to most things. There's very rarely in my career, I don't know about you, Leah, have I seen deals completely fall over.
Nothing is insurmountable. But the earlier you know what's going on, the easier it is to deal with generally.
Completely. So as I say, the due diligence could be time consuming for the sellers, but it is important, and unfortunately it's something you have to do.
Can't escape it. No.
You can't escape. And then I've termed it kind of stage 3 documentation. Obviously there's lots of legal documentation that is entered into as part of a transaction. They're usually standard, but the key ones from the corporate perspective that I get involved in are kind of the purchase agreements. Obviously, depending on whether we're selling the assets or the shares, it will either be an asset purchase agreement or a share purchase agreement. The negotiation can be lengthy, and I'm just going to run through a few of the key kind of elements that we tend to find get negotiated more than others. So the main one is limitations on liability. Obviously, as a seller, you want to try and keep as much of your consideration money in your pocket as possible. The basic way to ensure that is that you try to limit your liability under the purchase agreement. This can be done in a number of ways. So the first one is ensuring that you've made full disclosure against any warranty. So again, that links back to kind of the DD point. You've just got to be open and transparent. If there is anything there, tell the buyer about it and we can probably get it sorted. And then one of the other ways that we can limit your liability is specifying that no claims can be brought against you after a certain period of time after completion. So the norm is usually between 1 to 3 years. So 2 years is the sweet spot. If you can get away with 1 year, then you're in a good position. And then go on.
I was going to say, and I should kind of add in here that the reason you kind of have to provide these liabilities is because you're a limited company. Essentially, they're buying the entire history. So when you have things like staff members could bring claims years after an event and things like that, that's why these are in there. So it's not that you're going to hand it over and they're going to, if they cause problems, you're liable. That's not the case. This is for while it was in your tenure.
Yeah, exactly, definitely. And that links through as well. You can cap your liability to the amount of the consideration actually received. So those are ways that you can kind of limit exposure. But I always say to my clients, look, if you're upfront and honest and you've told the buyer everything, then there's they haven't got much to come back to you about as long as you've disclosed it in the due diligence process.
Exactly.
And I've never
sorry.
No, I've never come across people actively looking to catch someone out and bring a warranty claim, but there's always a chance, I guess.
There's always a chance, yes.
Yeah,
okay.
And that links on nicely because actually warranties is another element that is sometimes negotiated quite heavily. The buyer will obviously expect that you give warranties, and warranties are statements about the nursery being purchased, so kind of statements of truth about the business and how you've run it during your ownership. And if any of them transpire post completion to be incorrect, then potentially the buyer could bring a claim against you for a breach of that warranty. But obviously, if your lawyer's done their job right, you'll have all the necessary caps and limits that will offer you a great deal of protection in such a scenario. And then the other point I wanted to mention just was restrictive covenants, because that's another one that tends to be negotiated quite a bit. Obviously, the buyer's paying you money for your business, for your company. They're going to require some form of non-compete to stop you from opening up a nursery down the street. So we normally tend to find that the restrictions are anywhere between 1 to 5 years, and usually they're set within a certain mile radius of the nursery premises, and that can vary depending on the locality of the nursery and how many other operators are in the vicinity. That they can be quite heavily negotiated clauses, but again, it's very deal specific because it does depend on if the seller has any intentions of remaining in the nursery sector, or if they're retiring, for instance.
If they're retiring, it's irrelevant.
Yeah, they're not going to be worried. But obviously, for some people, they're offloading perhaps part of their group and they've got a couple of other settings. They still want to be able to operate those. So we need to ensure they're carved out, and also that they're not restricted from any other business interests that they might want to continue with post completion, but just making sure you get the balance right so that the buyer gets adequate protection as well for the value that they're putting into the nursery that they're buying.
Okay, that's brilliant. And I'm guessing, obviously, alongside all this, you've also got things like the lease, if there's a third-party landlord, or if there's which I know David's going to cover. So if there's a third-party landlord, you got that running concurrently. But the key thing is about having it running concurrently as much as possible, isn't it? And and the preparation is key, of course.
Yeah, definitely, because ultimately there's lots of different elements that have to all feed in and all have to be ready at the same time in order to get to completion. Like as you correctly say, you've got the property elements if you've got third party landlords, they can cause delays, as I'm sure David will probably allude to when he speaks. And then obviously you've got Ofsted elements, and then also sometimes if the buyer's getting bank funding, obviously they will have certain hoops that they need to jump through in order to have the money available. And let's be honest, completion isn't happening if the money isn't there. So that's an important work stream that also needs to kind of run along in tandem with those other elements. Yeah, completely right.
So essentially, the key is that you never want really one thing to be delaying everything. Ideally, you want everything to be running concurrently with the aim of tying it all up in a neat bow, which we all know doesn't happen. But that's the aim.
Sometimes, but not all the time. But that's life.
So I've got a question for you here. Someone sort of said, okay, so regarding a share sale and an asset sale, they say, I think I kind of understand the difference, but my property is in my limited company and the buyer doesn't want to buy it. So does that mean I have to have an asset sale?
An asset sale or a share sale?
Well, he wants to do, I think reading between the lines, he wants to do a share sale, but the buyer wants to do an asset sale.
Well, that's fine. I mean, you can just buy the asset, just transfer it out.
Yeah,
You don't need to
yeah,
buy the company necessarily in order
yeah.
to do that. So is it only
But
the company that sits in there?
it's only the company, and the freehold sits in the limited company, but he's not buying the freehold. So, I mean, I suppose obviously another option, but that's more an accountancy question, is about moving
Yeah,
the freehold out of the limited company in order to secure a share sale. So the legal
yeah,
viewpoint would be, well, it'd have to be an asset, but that accountant's viewpoint may be, actually, if you move it out and kind of restructure it, you can still get the benefits of a share sale on the actual goodwill of the business, couldn't you? So
yeah,
yeah,
exactly.
okay.
And
Okay. And then I've got another question here, which, I mean, I know what my answer would be. I'll be curious about your answer. So someone's saying here that they're going through due diligence and it is so much more extensive than when they bought. Like they were like, we gave them like hardly anything. We got hardly
yeah.
anything, but we seem to be having to give everything. Um, why is that? And is it all needed?
Well, is it all needed? I suppose I'm going to have to say
Yes,
yes to that, aren't I?
yes, yes.
But
They asked the
I
question,
mean,
there's probably a reason for it.
yeah, well, as I alluded to, obviously the buyer's entitled to ask as many questions as they want, and I don't know when this person obviously, bought their nursery previously, but obviously, within the nursery sector, it's extremely regulated. There are
Hmm.
certain elements that you need to ensure that the company you're buying is complying with, such as all the Ofsted DBS checks,
Hmm.
policies, safeguarding, reports and things like that all need to be checked, because ultimately, if they aren't correct, then it's going to be you potentially that's picking up the tab for those,
Yeah.
or you're going to have to spend a lot of money in order to rectify those issues post
Mm.
completion. And whilst you might have recourse to the seller under the agreement, that in itself can be expensive, time consuming, and just detract your attention from your new
Yeah.
business that you've bought. But the reality is, due diligence questionnaires are long-winded, but if you've got experts to help you through the process, then what I
Yeah.
always say is read through it. Anything you don't understand, we can have a call and we can literally work through each question. We see these due diligence questionnaires all the time, and we're familiar with what answers they're expecting. And
Yeah.
on the flip side of that, I mean, if you haven't got it, you haven't got it. You can't provide information or documentation that you haven't got. So sometimes it is a case of saying, yeah, we haven't got this policy.
Don't have
And
that.
then the
Yeah.
buyer comes back and says, okay, well, can you put this one in place, or can we, do something, take a little
Yeah.
bit off the price to cover me having to put this in place post completion?
Mm.
So again, being upfront and transparent about these things is usually a way
Key.
forward from a
Yeah.
commercial perspective,
Yeah.
in my view.
Well, to be honest, with my broker's hat on, I would say that yes, the due diligence is exhaustive and there is lots of it. But one of the nice things about this sector is values are going up, which is brilliant. I suspect you're probably getting more for it than you paid for it.
Mm.
And actually, though, because there is a greater financial risk and financing involved and everything like that, you would expect the amount of information they're going to want, belts and braces all the way to make sure they're fully protected. So
Yeah,
unfortunately, it's a side effect of the fact that actually you've got a really successful business.
Definitely.
So,
And something
that's
else
why you're having to do more.
something else
Yes.
I always say as well, linking into that, Leah, about the values, is that, if you've got 200 questions to ask, just think of it as an amount per question that you're getting in terms of the purchase price split. And that sometimes helps focus the minds a little bit more.
Really focus the mind, wouldn't it? Oh,
Yeah,
brilliant. Okay.
exactly.
I think that's a top tip. Okay. Well, thank you, Katie. Okay, so David, let's have a chat with you. You obviously you do a lot of the transaction work, and you do a lot of transactions for nurseries, and you kind of want to talk a bit about main delay factors. So yeah, so
Mm.
what's going on here? What is it that's causing problems in sales?
So typically you get the same few factors that are cropping up on
Mm.
virtually all transactions. If there's a delay on a transaction, more times than not, it's going to be one of these. So I'll run through briefly what some of these are, give a bit of an overview and how you can,
Yeah.
try and deal with them beforehand, because a lot of these delay factors can be dealt with by preparation.
Yeah.
Now, you're probably going to hear me say that a lot, because your sale doesn't start at the point where you've got an offer and heads of terms are out. It starts maybe a year before then, 6 months,
At
maybe even
least,
longer.
I'd say, yeah.
Exactly. Getting all this stuff in place. So, so I'll crack on. So the first one is due diligence. Now, this is more directed at sellers really, and getting prepared for that, that sale process, because as part of the transaction, the buyer's solicitor, they're going to want to do basically a full audit of the company. Now, I know Sarah touched upon this a bit before in terms of, like the staff contracts, for example. So, I mean, the way to think about it is they're basically looking under the hood of a car before buying it. And it's a comprehensive process, and the seller's going to have, a lot of homework to do. But I think getting this stuff in order, early on, but before we've even got a buyer, is ultimately going to make that process a lot more streamlined down the line. So these are things like like staff contracts, having those up to date, because some of them, how often do people enter into employment contracts and then they don't get looked at
things
for
just change
10
a
years.
little as you go along, and 15 years later,
and it happens. And so it's important that those are up to date, and not only that those are up to date, but that any other terms that have been verbally agreed, so like, I don't know, maybe like extra holiday or benefits, those are all sent over and disclosed as well. And you've also got things like commercial contracts, Ofsted reports, due diligence regarding the property. Now, this is all, again, these are all delay factors, because, for example, regarding the property, you've got things like, fire risk assessment, asbestos reports. So these are things that are going to be required. I mean, really, they should be in place anyway, but, running a business, things slip through the cracks. It's normal. But they are going to be asked for, and the buyer's going to want to see them. And if they've got a lender, the lender's going to want to see them as well. So it's pretty fundamental that all this stuff is in place, because if you're waiting until the point where inquiries are raised to deal with this, you might think, oh, I've not had an up-to-date fire risk assessment for 3 years. You've got to go and find someone to do it. You've got to book it in. They've got to come and carry it out. They've got to provide the report. And I would say most of the time there's going to be things in there which need to be dealt with,
or at least discussed with the buyer.
Yeah, I mean, quite often these reports come back, and there are some high priority things, some low priority things, some medium things. And, from a buyer's point of view, you're going to have an interest in this property, you're buying the business in this property. You want all this stuff up to scratch, and it's all got to be, compliant and correct. So it's important that it's all done. I mean, more often than not, you don't tend to get actual issues arising from them that aren't dealt with, but it's more just the time factor from getting them carried out to getting to the point where everyone's happy with it. So
and I don't think I've ever seen a seller who hasn't been surprised at how in depth the due diligence is and what they have to supply. So they, when they sort of say, "Oh, don't worry, I've got everything," probably they really probably haven't. Absolutely not. There's always something.
I think this is it. I think it's just so comprehensive, and that's just the way that transactions are done now, when it's everyone wants to see and know everything, really. And like you say, sellers might think, oh, I've got everything in order, it's fine. But when you actually dig deep into it, you might think, oh, I had a new member of staff that started 2 years ago. Oh, I don't think I ever got their employment contract back. So it's things like that when you actually get to doing a deep dive into it, you start to realize that, oh, maybe all of these things aren't in place, which is why it's it's a good idea to start looking into all this stuff from arguably before you even start thinking about selling the practice, really, because it's all gonna be needed. And it's just important to kind of get it all boxed off, because it's only going to make everyone's life easier and make the transaction a lot smoother, and stop you being chased for everything.
One thing I say, due diligence lists, they will vary from solicitor to solicitor. Everyone will ask different questions, but 99% of the paperwork is the same. So if you can just find that paperwork and get it in one place, you've done half the battle. And I think for a lot of people, especially if they've had a setting for a long time, maybe they're more paper-based, it's just a case of scanning it, because everything's done online now. It goes to a data room. So, that can also be incredibly time-consuming. And if you're doing it gradually in the build-up to sale, it's going to save you a month at the beginning of the transaction, isn't it?
Yeah, I mean, maybe longer. I mean, how many times have we seen, sellers taking 6 weeks longer,
Mm,
getting documents together? And I suppose it just comes back to, do they need to get employment contracts re-signed or get fire risk assessments booked in, and things like that, especially when, you know, most of the time people try and keep these transactions under wraps.
mm,
It can raise questions when you're doing everything all at once,
yeah,
I suppose. So it's just, again, it just comes back to the preparation and making sure you've done as much as you can as early as you can, because it will just it streamlines the process
yeah.
massively, and ultimately it's going to make the process a lot less stressful for the seller and for us, obviously.
Well, yes, and that's preferred for us as well, certainly, without
Yeah.
a doubt. Okay, and then what other delay factors then? You said there was a couple.
Yeah, so this is probably, I would say, the biggest one, and it's not going to apply to every
No.
transaction. But when there's a lease involved, and you've got a third party landlord, this is, I would say, 9 times out of 10 a problem.
Yeah.
Very rarely is it always is it nice and
Is it
smooth sailing.
straightforward?
And what
Yeah.
yeah, it just doesn't happen. And what I mean by that is that if you don't own the property and you've got a third party landlord, you'll be operating the property on a lease. It might be 20
Mm,
years, 15 years, 25 years, however long it is. Now, it's so important to have a look at this and understand what the position is from the outset, because if you've got a lease that might only have 4 or 5 years left on it,
mm,
might be fine. That might be fine for you, but it's not going to work for a buyer. And the reason is because not all, but the majority of buyers nowadays, they're using funding
yeah.
to go ahead with the purchase, and more times than not, it's a requirement of most of the lenders that there's at least 10, even 15
Mm,
years remaining on the lease. So what then needs to happen is, well, you need to get that lease extended, or a brand new lease needs to get
yeah.
granted directly to the buyer. Now, if you've got 4 or 5 years left on the lease, there's no obligation on the landlord to grant a new lease. So again, it just comes back to preparation and making sure you know what the position is early. Because
Mm,
if let's say you've only got a couple of years left on the lease and you're thinking, well, I'm thinking about selling maybe this time next year, then it gives you plenty of time to open up a line of communication with your landlord and
mm-hmm.
say, can we look in the lease is coming to an end? Can we look to extend the lease?
Yeah.
And then by the time you've got your buyer, you've already got a 15, 20-year lease. It's one less thing to worry about. And everyone's really happy,
Mm,
because if you don't, and if this gets picked up at the point of transaction, I mean, we've seen it before. Landlords can take weeks, even months to
even
respond.
years in some case.
Even
Yeah.
yes, even years, and we've seen it happen, and it does happen. And there's rarely an urgency from
No,
landlords to
they
deal
don't.
with these
They don't
kind
have
of
any
things,
vested
because
interest in moving faster than they have to. Yeah.
exactly. And we've seen it before where landlords might turn around and say, "Oh, like, I'm happy to grant you a new lease, or I'm happy to grant your buyer a new lease, but I want 10 grand in order to do that, or I want to increase the rent by 20%."
Mm,
So again, if you're selling your nursery and the landlord knows you're selling your nursery, they know that you can't really do that
yeah.
without them. So they're gonna, and it doesn't happen often, but it does
It
happen
can
where
happen.
they look to leverage the situation, which again, why it's important to get it done early on. You don't even necessarily need to be transparent with them.
Mm-hmm.
That's the case. I mean, people operating out of a limited company, then no, they don't even need to. The landlord doesn't
It's
even need to know
easier.
about the
Yeah.
buyer. Yeah, exactly. So it's just important to get it from a seller's side, to get this looked at before day one, really. And from
Mm,
a buyer, the first question they need to be asking, if it's a leasehold, is how long is left on the lease,
yeah.
because it's we've seen horror stories, and it does come up a lot.
Yes. And I would also say, I mean, add to that is that a lot of people they go, oh well, no, I've got my lease and it's fine, and it's a 15-year lease or it's a 20-year lease or da da da. But also, those little clauses in the lease that suddenly go, did they not actually notice this? Because actually this
Yeah,
is this is a serious clause that will impact how the buyer will end. So,
yeah.
not just getting the lease sorted, but also having a good understanding of your own lease prior to
Well,
starting.
yeah. This is it. So, I mean, just to give a very recent example of that, a new lease which has granted for 20-25 years, we're
Sounds
thinking
amazing.
great, but the landlord wants a break clause in there after 5 years, 10 years. So you're thinking, well, hold on a minute, this 25-year lease is to a degree pointless if the landlord
Mm-hmm.
can kick me out after 5 or 10 years. And from a buyer's side, are they really going to want to spend and invest all this money in a setting which in however long they get kicked out of, and they can't really do anything about
Yeah.
it, really? So yeah, so it's important to again, just preparation, to
Mm.
look into all of this beforehand, make sure you know where the potential hiccups are, see if they can be dealt with, like I said, before you've even got a buyer, really.
And I think a particular nursery in this sector is you have a lot of people who are on maybe school sites, or they're on like church sites, and I've seen one very recently where we've just renegotiated a new lease, but actually after year 3, at any point they can give 6 months notice.
Yeah,
20-year lease, but year 3. Actually, it's a
yeah,
3-year lease. That's what it
yeah,
is.
yeah,
And really understanding how that will impact you, getting the right advice when you're doing the lease is obviously key. But the best time to get advice on your lease is when you're doing it. The second best time is now. So
yeah.
go and do that
Completely
now.
agree.
Yeah.
Yeah, I
Okay.
completely agree. And I suppose I was going to come on to this a bit later, but it kind of slots in nicely now. But making sure you've got your specialist team in
Mm,
place, whether that's lawyers, accountants, brokers, people that know the industry, because it does make the process a lot more streamlined when people are familiar with the nuances
yeah.
and know how things work. That may not necessarily be relevant in a sale of a hairdresser or a
Mm,
pub or something like that. It's important to make sure you've got that team in place early on,
absolutely.
because it will save you in the long term.
Mm,
Absolutely,
absolutely.
for sure.
Okay.
Okay, cool. Right, next one. Now, this is probably similar to the due diligence point, but is more directed at buyers, and that's in terms of finance and making
Okay.
sure that everything finance wise is ready. Again, lenders have so many bits of info and requests and documents that they want, so it's making sure that all of that is you've got it all, you get it quickly.
Mm,
From sellers, it's making sure you've got up-to-date accounts and tax returns and all that important info
yeah.
ready to send to the lenders, and buyers, making sure that you're dealing with security documents, requests for info, anything else really that the bank needs, because again, we've seen instances where security documents get sent over, the buyer's sitting on them for 2-3 weeks, and the transaction can't proceed,
Yeah.
and the bank can't take the next step until that's dealt with. So
Yeah.
it's just making sure that everything is moving smoothly and in the right direction
Absolutely.
at all times, really. And I would say the last point I will mention today is getting documents agreed.
Mm,
Now, obviously, there's negotiation in all documents, but my point here is more the line, well, what's actually important to you as a buyer or a seller? Because there's no point if you're a seller and you're thinking of leaving the industry and not working, you're going to retire, or you're thinking I'm done with nurseries, I'm going to go and work in a supermarket for however long, then there's no point spending 2-3 weeks negotiating over well, how far from the
yeah.
current nursery can I work at another nursery, because it's not relevant. And all these small points, they can take time to negotiate.
Yeah.
You may say, 1 mile or 2 miles or 3 miles, but if it's not relevant, then there's no point
Yeah.
spending time negotiating. So it's just, and again, this works for both parties really. Just think about what you want and what's important to you, because that will kind of that can dictate
Yeah.
a number of timelines as well.
And that goes back to
think
working with your advisors and making sure that they know what's a deal breaker for you and what's not.
yeah, exactly. It comes back to that, and it comes back to knowing what's important to you, making sure your advisors know what's important to you, and just making sure everyone's kind of on the same page, because transactions work a lot smoother when there's open lines of communication between everyone, between brokers, lawyers, buyers, sellers. When everyone's all on the same page, things do run a lot smoother, and there's less bumps in the road. So I think those are probably the main things. This is one point I would say to take away from today for everyone. It's preparation is key.
Yes.
And think about it now. Don't think about it on day one when you've got a deal agreed, because it's not too late. But I think, Lee, as you said before, the best time is 6 months ago. The second best time is is today.
Yeah.
So all these things, and when you think you've got so many variables and so many different factors and things that need to come together for a transaction to go through, there's always going to be little things. So if you can get as much as you can done and prepared and organised beforehand, it will just make everything move a lot smoother for everyone.
I think there's no such thing as an unstressful transaction. Something will always happen.
There's always something. There's always a spanner in the works somewhere.
But actually, there's so much you can do to prepare yourself and the setting in the business to get there. And if you can put that groundwork in place, and if it is that you've literally woken up today and gone, I'm going to sell, and you've never thought about it before, there's still things you can do. It's not too late.
Yeah,
because these things still take time. So you can kind of work while other things are happening to make sure everything's as easy as it can be. And that's the key thing, isn't it? Okay.
Yeah, absolutely.
So, one question that came in, and again, I always smirk when this question's asked because it is a piece of string question. How long does a transaction take?
How long does a transaction take? Well, it is very much
how long is a piece as well.
How long is a piece of string? It completely varies. Like I said, there are so many different things to consider. You've got due diligence, you've got lease, finance. There's all these different parts. I would say typically, if people do what they're meant to do and things move smoothly, 6 months maybe as a ballpark. If you've got a landlord who doesn't reply for 6 months, then you could be looking at a lot longer. But I suppose as a ballpark, that's probably an idea of something to aim for. But it does just depend, because if you can have on day one a seller that's got all their documents ready, all the due diligence ready, their lease is long enough, the buyer's organised with finance. If that's the case, there's no reason it can't be done. It can't. Well, it can't. It can be. Things can be done in 3 months or less if everything's ready to go. So I suppose timelines are really dictated by the parties. To be honest.
Yeah. And I think, that includes all stakeholders as well. You need willing buyer, willing seller, willing solicitors who know what they're working towards and kind of know that what timeline we're working towards. And once you've got all of those people in place, and you've done the preparation, so maybe what obstacles you need to overcome, it can still be a very reasonable timeline, can't it? But all it takes is for one of those things to go off kilter.
Well, that's what it is. I think, it's you're only as weak as the weakest link in the chain. That everyone can be on it, organised, everything ready. But if a landlord, if you've got no lease, then you've effectively got no transaction, no matter how organised you are.
Yeah.
Really.
Okay. Wonderful. And so a few more questions before we finish up. Sarah, this might actually be one for you. So staff-wise, when you're looking to sell, should you be telling your staff what's going on and that you're selling the business?
There's no legal right or wrong.
Okay.
What we would say is that it's best not to tell the staff in the first instance, because people don't like change. So they get worried, and they might start looking for jobs elsewhere. And what you need to be able to sell your business as a going concern with the same staff members around, because ultimately that's what's keeping your clients coming to the business. It's the staff team and the buyer of, I know you can't buy people, but they are buying the team. So we would always say, don't tell the staff in the first instance, because we want to get much further down the line before we start telling the staff and complying with the legislation whereby you have to tell the staff a certain amount of information depending on the transaction. So it depends how you're selling your business, whether it's an asset or a share deal. And if a transaction can take a year, why would you tell your staff a year in advance? You don't need to worry them.
No, and
Uh,
you're already stressed, so you're just adding to your stress because they're
exactly.
stressed.
So
Yeah,
we would say keep it quiet. You don't need to tell anybody at this stage, and your advisor will tell you when's an appropriate time to tell the staff to comply with the regulations. But I would say just to say that I think where people go wrong with and why sometimes there's delays with the transaction is that they don't put any time to one side. So they're busy business owners who are doing their day jobs and they don't realize how much work
they're trying
they
to
have.
sell a business on the side. Yes,
Yeah.
yeah,
So I think you need to be prepared to put some hours in because if you wait and you're saying, well, I'll do it next Sunday morning, that's another week. And then it's got
yeah.
to, and it goes like this. And I think sometimes if you do have, let's say you have a manager and you really trust that manager and you want to tell them that you're selling.
Because they know where all the paperwork is as well.
They know
So
where all the
yeah,
paperwork. And also, it will be their job to
hmm
get the paperwork together, so they
hmm
will do it during their working hours. Sometimes that can really help.
yeah.
But I think it does depend on the relationship that you have with that
Circle of
manager.
trust. Yes,
Yeah, but it
yeah,
can help to maybe
yeah.
tell somebody who, if you are slightly um, at a distance from the paperwork and not quite sure where to find certain things, which happens. But you may have to tell certain people to get that
Yeah.
paperwork. But generally, we say don't tell the staff, don't upset them. Let's just leave it and deal with that headache later down the line.
Yeah.
And also, you might tell the staff, and then the buyer pulls out.
Well, that's it. Things change.
And then you're back to square one.
Yeah.
So yeah,
Yeah.
we would definitely advise you when it's best to tell the staff, but it wouldn't be straight away.
And picking up on a point you made there, then make sure you have time to sell, and you've allowed time to sell. We've all heard stories about sellers who have had to pretty much break into their own business on a weekend to find the paperwork in order to get it, the due diligence done. So yes, it is about making sure that that what time you're going to have to put in. And then that comes back to David, who's very much like, well, if you were prepared and you knew where all this stuff was beforehand, you could literally go to your solicitor with I found a buyer, here's everything you need. Aren't I smug? So, make sure you allow for that time, really. Okay. Okay, guys, so we're going to finish with one last question for you all. And that is a top tip. Okay, so if you were working with a client, be it that they're, dealing with HR issues, running a business, not looking to sell, or maybe preparing for sale, if they could go and do one thing now that's going to make their lives easier and get them better prepared, what would you recommend? So, David, you first. What do you think?
Well, preparation, like you said, making sure you've got up-to-date documents, policies, all this stuff is in place. But if you've got a lease, you're checking your lease first. That is absolutely number one.
You're brilliant. Fantastic. And Sarah, one from you?
Yeah, I think for me it would be for HR and employment. Whether you are looking at buying, preparing for sale, not too sure, you think, oh, I might have another 5 years. It doesn't really matter where you are in that timeline. But I think what's really important is that you recognise that HR and employment law is one plate that you have to spin as a busy business owner. And you're not expected to know everything. So you should take HR support and advice to make sure that you are up to date. And that you do have, as David said, the correct contracts and policies and procedures in place. And that will set you up not only to ensure that you have a very happy and profitable team, also it will make you a very happy seller at the end of the day, because your job will be so much easier. And I think we all like to have easy jobs, don't we?
We love an easy job. We love an easy job.
So I'm not sure why I went into the law.
I was going to say, we love an easy job, and when we all find one, it's it'll be amazing. But luckily, we love what we do as well, though, so that helps.
Yeah.
And so, of course, Katie, the same question to you. What's your top tip?
My top tip would probably be preparation and the kind of health check of your company or your business, because as we've alluded to, the due diligence process is long, so there's no reason why you can't kind of undertake a health check and kind of do I suppose, a dummy run of DD whilst you're not having the kind of time pressures of being involved in the sale and all the other pulls on your time. You could just work through it at your own pace and make sure that you've got everything you need, which will then make it your business more attractive to the market in any event, and also make the process generally a lot smoother. So preparation would be my probably top tip.
It feels like top tips for everybody are preparation, preparation, preparation in the style of Labour, education, education, education. It's so important we're saying it 3 times. Okay, guys, we hope you found that useful. We have covered a lot of information today. So if you have any further questions, please drop them in the comments, or all of our links will be in the bios and everything. So you can contact us directly if you want to speak to one of us in particular. And in the meantime, all that's left to do is say thank you very much to Sarah Buxton from Buxton Coats, to Katie Shaken from Shakespeare Martineau, and David Nezri from Abraham's Dresden. Thank you so much for joining me, guys. I know firsthand how busy you all are, so it's very much appreciated. And we'll leave it at that. Have a lovely evening, everybody, and hope to see you again soon.